some of those services be brought here from Richmond instead of everything going up there. What do you have any sort of numbers or percentage, or what type of split, or what type of, could you expand a little bit on your suggestion there? I mean, certainly that's a big concern here as to what might happen to South Carolina people, South Carolina employees.
Right, sure, and that's a concern of the ORS as well. And I don't think I did not really evaluate what an appropriate retention number would be, because I think that really depends upon where the strengths are here locally at SCANA Service Company compared to at Dominion Service Company in Richmond. And I think that Dominion would need some leeway in that process, but I think it would go a long way if you put in as a condition that you need to put some functions here. You can't just cut and gut and move everything.
So you're suggesting put that in our final order?
I do, yes.
Yes, sir. Well, thank you. That's all I have, Mr. Chairman.
Thank you. Commissioners, other questions? Commissioner Irvin.
You also, believe, referenced in earlier testimony that there were certain other conditions that you thought might be in the public interest, and I don't think we've addressed that yet. Could you kind of summarize what those would be?
Yes. I don't know if you have a copy of my surrebuttal testimony in front of you, but that last exhibit, LK8, these are a comprehensive list of the commitments that Dominion and SCANA and South Carolina Electric and Gas all have made. And in addition to that, additional conditions that ORS thinks should be made. And, for example, we think it should be on the list that Dominion says they're going to take the transaction costs, and that's not going to, those costs are not going to be charged to South Carolina Electric and Gas customers. Same thing on transition or integration costs. And then in addition, we have certain rate-making conditions that Dominion says, oh, you don't need these conditions, but we think you need to have them formally in a list and say, yes, we order these conditions. Then we have rate-making conditions. For example, one of the commitments that Dominion has made and South Carolina Electric and Gas has made is that it will not file to increase base rates until 2021. So it's a 2-year base rate freeze. So that should go on the list of commitments and conditions. Then there's conditions affecting the cost of new generating capacity. One of the commitments that the applicants have made is that they won't charge customers for the Columbia Energy Center, $180 million. That should go on the list. Then conditions affecting affiliate transactions. No preferences, how those transactions should be costed out to protect the regulated utility customers. And then conditions regarding local management, the headquarters, and access to books and records. You want to maintain access locally to the utility executives, the books and records, and local management. And then conditions regarding local employment, and then conditions regarding service quality, which Mr. Baudino addressed, conditions regarding credit quality, and then additional conditions that ORS recommends. For example, I don't think you want Dominion to parse out the gas business of South Carolina Electric and Gas and essentially restructure that so it's not part of South Carolina Electric and Gas. So we have that included in these commitments and conditions. But that exhibit LK8 attached to my surrebuttal testimony is pretty comprehensive.
Thank you. And finally, it was suggested by Dominion that there might be some ways that they could help Santee Cooper. Of course, as you know, Santee Cooper is a publicly owned utility, and they don't pay taxes. And so it's unlikely that Dominion or any other publicly owned utility would want to buy them But Dominion made it public statements recently that there might be some ways that they could help the Santee Cooper ratepayers, because while they're not directly governed by the Public Service Commission, we're still concerned about those people because they're residents of our state.
Sure.
And as part of a state energy plan, they've kind of being left out in the cold in all this, unless there's some way they could benefit. And can you think of any ways that Dominion could help Santee Cooper ratepayers?
Well, as I understand it and again, this was from reading a newspaper article, not actually seeing anything such as a proposed agreement or anything of that nature, but very conceptually, as I understand it, Dominion would be or could be interested in providing shared services or centralized services to Santee Cooper due to their greater economy of scale. Same thing, with doing that for SCANA and South Carolina Electric and Gas. So I would imagine that entering into an agreement like that could be beneficial to Santee Cooper, and if there was some type of a management fee or a shared savings, that could be beneficial to Dominion.
And do you think it would be appropriate in the public interest that we ask for such a proposal or suggest that they enter into discussions along those lines, flesh it out?
I don't see any downside from that at all.
Because it could be mutually beneficial.
Sure, right, yes.
Dominion could raise some revenue from those management skills, and Santee Cooper ratepayers could benefit from the lower cost of services and fuel and so forth.
Sure.
Thank you.
Thank you, Commissioner. Commissioner Williams.
Thank you, Mr. Chairman. Sir, it's been a pleasure listening to your testimony.
Oh, thank you.
I don't think I've ever had the opportunity to question a master global accountant with a third-degree black belt.
My wife thinks maybe I should go for an interplanetary, but she thinks it's hysterical. But
To infinity and beyond, sir. Sir, I would like to highlight some of your testimony, especially your testimony regarding the decision that we have to make, policy decisions that we have to make, and all the considerations that go into this decision. And I'm sure you wouldn't be surprised to know that the public interest is high in this matter before us.
Yeah.
That wouldn't surprise you, would it?
no, not at all.
In fact, it's so high that you're being live streamed right now.
That's what I understand.
Globally.
We could inform the whole citizenry of the state about chartered global management accountant.
That's right, sir. The public interest has been so high that even some of my colleagues have been featured on wanted posters, Western wanted posters.
Sorry to hear that. That doesn't sound good.
The public interest has been so high that folks have shown up to hearings in pork barrels, just concerned about what went on with this project. And what's interesting to me is that throughout this testimony from ORS, there's been a lot said about what they did not know. If we would have known what was actually going on, we would have made a different decision. We would have made recommendations. There would have been some notice. Something would have been done differently. At least that's what I draw from some of the testimony that has been presented to this commission by ORS witnesses. And now we're here listening to your testimony about ORS's recommended plan, the optimal plan, and how ORS believes this is the best plan, right?
Yes, that's right. How to clean up the mess.
How to clean up the mess. That's a good way to put it, because we are indeed
You're in a cleanup mode.
in a mess.
Question.
But this ORS plan, it doesn't completely refund, if you will, the cost of this failed nuclear project to the ratepayers, does it?
It does not. It provides for recovery of some of the costs and allows the company to retain some of the revised rates that it collected in prior years.
And for the initiated, for the commission, the lawyers, and the subject matter experts, I think that sort of is understood that plan doesn't do that. But to the layperson, they may not know that even under ORS's best case scenario, the company still recovers for some of that failed nuclear project.
That's true.
And there's been some talk about bankruptcy. And in your opinion, bankruptcy is not realistic. The company is not at risk or danger of bankruptcy if this commission were to adopt ORS's optimal plan.
That's right.
That's your opinion.
That's my opinion, yes.
Um,
Even less likely if the commission adopts the customer benefits plan or something similar to it. But starting with the ORS optimal plan, that provides sufficient, reasonable, just and reasonable rate, and then we believe that it's sufficient to provide the continued existence, whether SCANA merges with Dominion or not. And if, on the other hand, this commission decides to do something different than the ORS optimal plan and provide even more, then there's even less likelihood. Instead of 1%, it might be 0%. Obviously, you could tell that there's a balance in there. And
I agree, sir. Now, are you willing to put a percentage of the likelihood of bankruptcy with ORS's plan?
I would say it's near zero.
So your testimony is that 1%?
Closer to that, yes.
Close to 1%.
Yeah.
A 1%.
I mean, there is a probability. I think it's highly unlikely.
So if it were to happen, since we're in the realm of a hypothetical, and I don't mean to take you to law school, but if we're in the realm of a hypothetical and it were to happen, what would be your response to that?
Well, I think that nothing would change initially. There would be an automatic stay of the interest and debt repayment, as I understand bankruptcy law. So that would, at least initially, unless and until that automatic stay was lifted, definitely improve South Carolina electric. And it would depend on who declared bankruptcy, whether it was the utility or SCANA or both. But let's just limit it to the utility. And there would be an immediate improvement in cash flow because there wouldn't be any more interest going out the door, all else equal. And then there would ultimately be a resolution of all of the issues in whatever manner that, whatever shape or form that ended up being. But there would be a termination point where those issues are resolved.
Do you think rates would increase?
I don't.
So your testimony is even though highly unlikely, even if SCENG is forced, if you will, or chooses bankruptcy under ORS's optimal plan, the ratepayer would not face increased rates.
I don't think so. Not directly. I mean, over time, there may be a higher cost of debt. I don't know. But that is a possibility. And so from that perspective, over time, as debt is issued in the future, that may have an impact on rates. But to get out of bankruptcy, I don't think so. Particularly if the rate is justified, it's upheld on appeal, or where it's affirmed. In that case, the company has options within the bankruptcy court, and that is to restructure its capital, its debt, and its equity for that matter. But instead of on the revenue side, it becomes on the debt side. But the focal point becomes on the debt side.
I want to ask you this. What do you make of Dominion's offer to come in and essentially save the day? Outside company, outside of the state of South Carolina, that is, coming in and making an offer to essentially save this drowning local jewel, as it's been called. I noticed your suggestions on, I think it's LK8, Exhibit LK8, in your Sir rebuttal testimony. But I'm just curious as to your thoughts as a global accounting expert. In all seriousness,
I will never live that down.
What do you make of Dominion's offer?
Well, I think that it's not sufficient from a rate-making perspective. In other words, it still provides for excessive recovery. But if you look at some other aspects of it, there's no question that it brings a credit support to SCANA and South Carolina Electric and Gas, brings deep pockets. They have the capability of achieving savings from synergies. And, I think the service quality could be improvements that Mr. Baudino addressed could be addressed regardless of whether there is a merger or not. But there's no question that Dominion brings value, to SCANA and to South Carolina Electric and Gas as a general proposition. But that value that they bring comes with a cost, too. And the cost is their rate plan. And ORS believes that cost is too high. And so that's why we're recommending the ORS optimal plan. And if Dominion walks, Dominion walks.
You were asked about Speaker Lucas's letter. What do you make of that letter? You had a chance to read it, right?
I did, yes. I'm not sure what happened.
One of the things that this exhibit, hearing exhibit 53, I believe, 53. One of the things that stood out to me in that letter is that the speaker, or at least the speaker's letter, suggests that the Dominion proposal returns 90% of the money each ratepayer has paid for the failed nuclear project through rate credits. Do you agree with that?
I don't have any idea where that came from. I don't think that's correct.
And if it let's say it was correct, or let's say it is correct, I mean that's pretty significant. Wouldn't you agree with that?
Well, if the customers have paid $2.2 billion, and I suspect that the way that 90% was derived is the Toshiba proceeds plus the return on the Toshiba proceeds, which is $1.9 billion, and they compared that to the $2.2 billion that customers have paid, and they said, 1.9 divided by 2.2 is 90%. I don't think that's a fair or correct calculation, because the Toshiba proceeds belong to the customers. They're set up as a regulatory liability. It's not a return of what customers have already paid. And the return on the Toshiba proceeds is the carrying value of the avoided financing. I would strongly disagree with that representation. It does not return one penny of the money that customers have paid.
All right, sir. Thank you for your time.
Thanks, Commissioner Williams. Commissioner Elam.
Just want to follow up a little bit about something you just said about bankruptcy. Did you say that you didn't expect rates to move at all if SCNG or SCANA goes into bankruptcy?
I don't see why they would move. And the reason for it is that, unless there's a rate case in the normal course of South Carolina Electric and Gas's business, how would they increase? I mean, the judge can't come in and, override the commission's statutory authority. Again, not speaking as an attorney, but as my understanding of the process. And, if your rate order in this proceeding is upheld, there's no place to go as far as rates are concerned.
Well, you said during your answer that you would expect that the cost of debt could go up.
Well, that's right, over time. As South Carolina Electric and Gas would issue new debt, that would potentially raise the cost of debt in the aggregate or on an average basis.
How much?
I don't know, because I think that the next issuances of debt actually will bring down the average cost of debt, even if it's more expensive, by 25 basis points or 50 basis points, because if it's in the 4% rate, right now, South Carolina Electric and Gas's average weighted cost of debt is 5.56%. They issue any debt that's less than 5.56%, even if it's higher because they're no longer investment grade, it's still going to reduce that 5.56 just as a matter of the averaging process. So, I mean, it would have to go up very, very, very significantly. It would have to go up to more than 5.56% to raise the cost of debt on the overall debt portfolio.
And you don't think that a company in bankruptcy with this kind of debt load would be getting costs of debt above that level?
I don't think so. I mean, there's debtor in possession financing and things like that we can't really know for certain, but I don't see any reason why it would be greater than 5.56%.
Thank you.
Commissioners, anything else? Mr. Richardson, any redirect?
Chairman, if you indulge me just on one matter.
Just one?
Yes, sir.
Because there's places I got to go. That's my thought. But I'm going to give you the benefit.
Colin, do you remember when Mr. Ziegler was talking to you about that delay, that reduction in revenue that
Get in front of that microphone.
Thank you very much. The reduction in revenue that would occur from the ORS plan?
Yes, and I disagreed with him.
And if I'm pulling up your summary chart, the very first one you had on, that talked about and showed the termination of rates and then gave the increase that would occur.
Yes.
If you look at 2019, just for example, because you did the 2020 as well, but the ORS plan would actually return on the NND cost more than the experimental rate, right?
Well, that's right, and because you would reduce or eliminate or terminate the revised rates that are presently in place, $445 million, and you would also terminate the experimental rate. So right now the company is recovering $78 million. The net recovery of the revised rates less the experimental rates, the credit. And instead, what the ORS plan does is replace that with a recovery of $86 million. Now, those two tax line items, the reduction for the Tax Cuts and Jobs Act savings and the one-time refund, those are going to be there regardless of whether it's the ORS plan or the CBP or the no merger BP. And so, those are not incremental. The two tax line items, those are not unique to the ORS plan. Those are going to happen.
Mr. Collin, those are savings to the company that are simply being passed along to the ratepayers, correct?
That's exactly right. The company has lower expenses because of the Tax Cuts and Jobs Act and has been deferring those savings since January 1 of this year, and that would be the one-time refund. So that one-time refund is going to happen regardless of whether it's the ORS plan, the CBP, or the BP. And then the ongoing reduction for the Tax Cuts and Jobs Act savings, that's going to happen under all three plans too, or four if you include the alternative CBP.
Mr. Collin, both of those numbers are unrelated to the NND cost and cost recovery.
Yes, that's right. These are non-NND costs because we have the savings from the Tax Cuts and Jobs Act included in the NND recovery, that third line item.
And last question, Mr. Collin. What is your understanding of why this non-NND, unrelated to the new nuclear and the abandonment itself, why is this issue in this proceeding?
Because the joint applicants put it into the proceeding. You have before you a tax proceeding right now where you've directed the utilities under your jurisdiction to defer those savings. And I believe that the ORS took the position as that they wanted a rate reduction right up front. South Carolina Electric and Gas argued, no, the appropriate place to address that is in the merger proceeding, which was also pending at that time. And so that's where it is. It's here, right here, because that's what South Carolina Electric and Gas wanted.
No further
So,
questions.
It's an issue in this proceeding.
Okay, thank you. With that, anybody can recross on that question, that one question. Well, this reminds me of a story about a great philosopher, Ron White, who was thrown out of an establishment one night and arrested. And he knew he had the right to remain silent, just not the ability. There's nothing else. Mr. Collin, thank you for your testimony. You may step down and you are excused. And we are breaking.
Sir.
10 minutes.